found that we are there, did you suggest any solutions for this?
Yes, we suggested changes in pre-trial steps, the attitude of lawyers, how lawyers should take this, and even we, quite humbly, we suggested that certain new changes.
Are you able to list down some of those, or is it a confidential
It's
document?
not a confidential document, but generally we talked about pre-trial steps, on educating even specialized judges on expeditious procedures, to train them, to introduce technology, to have e-filing, and to also agree on matters such as timelines, court time. We suggested court time. Now in Singapore, you would at the very outset, as the plaintiff's lawyer, you would say, I need 3 days, and this is the time. So you at the very outset, you have to decide how long you are going to take for your entire case. The defendant also is able to, his counsel is able to decide that. So the entire court time is pre-booked, and you know when it starts and you know when it's going to end. So you can also, as a lawyer, state your fees, because you know the time period you are spending. As you and I know, we lawyers, we have our efforts is measured in time. So without time, without knowing the time, we cannot say our fees. So yes, we suggested things like that. We submitted that. And we hopefully, through this more comprehensive National Law Conference report, where we are specifically, now that report was submitted to the World Bank. So the World Bank is taking steps through the stakeholders in a different manner. But this NLC report, we are hoping to submit it to the stakeholders with all of these included, to address our issues.
Arbitration, out of the many ADRs, alternative dispute resolutions, from conciliation to mediation, arbitration was very popular in Sri Lanka. But we see increasingly it's declining, and even I have experienced clients are telling us, no need to put arbitration clause, it's just additional money. What is your view on this, or is this true?
The fact that arbitration would cost more money than coming to court is a matter which I would agree. Because for a sitting you are required to pay for the arbitrators. So, and those fees are quite significant when it comes down to payments compared to coming to court. So you go through a process of arbitration. Now, even in this World Bank report, we suggested certain changes to be made to arbitration. It's all about the attitude and the culture which needs to change. So arbitration should not be considered a court or in the context of an adversarial setting. It has to be a dispute resolution mechanism. That is what arbitration is known for. So what happens in arbitration in our culture, unfortunately, is that is also a court process. So you object to documents, you apply the strict principles of the evidence ordinance, and with all due respect, we lawyers get into that process. Now, if you see an arbitration in an international arbitration in respect of construction matter, you will get a construction specialist sitting as an arbitrator. So you will get industrial specialists to sit there to resolve this. So after the process of obtaining an award in arbitration, which will take from 6 months to about 2 years, you need to enforce that award. So that also takes time. Now what is enforcement? This award lacks teeth, Chanakya. You need to give that award teeth. Because the party who the award is against is not going to comply. Yes. So you need to take that award, bring it to the High Court, as it's stipulated in the 1995 Arbitration Act. You deposit it in the court and you seek enforcement. That process will take
It's another court case.
Yes, 2 years. So it will take a good 4 years for an arbitral award to be obtained and then enforced. So yes, arbitration thus would be quite unattractive unless, to certain clients, we advise them to have Singapore as the seat of arbitration in the dispute. So it's more expensive, mind you, to go to Singapore, but still you will have an expeditious hearing.
Yes. Now, talking of Singapore, you have participated, I know, in SIAC
yes.
arbitrations. Can't we achieve that position with our drive and our will to make it a dispute resolution hub?
We can. There is nothing.
What needs to change?
We need to have, now, there are two aspects to it. Firstly is the center. The center of arbitration, we need to have a proper secretariat to run that center. Yeah. So a proper secretariat, possibly a foreign law firm can handle that secretariat work. So that ensures efficiency and strict timelines, and also a set of arbitrators whom can be selected as an arbitration panel, where parties can select their arbitration in respect of the nature of the dispute. So that aspect of ensuring a proper center is set up can be taken up, and timelines to arbitrators given. So arbitrators' fees, now if you look at SIAC, you don't pay the arbitrators on a sitting basis. There is a percentage from the claim that is the fee of the arbitrator. But here it is not the case. So sometimes you might go into an insurance arbitration. Your actual claim must be about 1 million rupees, hypothetically, but you will be paying arbitral fees, which is more than 700 to 800,000. So, but if you have it as a percentage, there is an incentive to the arbitrators to expedite the hearing. So those can be brought into the institutional rules of the center. Then the second process is the court process. So enforcing an award, recently in the recent concluded National Law Conference, we had a specialized session in arbitration, and we had a Singaporean expert sitting in the session, and also a learned judge from the commercial court, who suggested that even objecting to enforcement of the award has to be considered a serious nature. Serious thing. You should not permit any objection to be filed. So when you seek to enforce your award, there should have been an application to set aside the award at that time. That is also provided in the Arbitration Act, right. Section 31 and 32. Yes. So, but here, unfortunately, the process is dragging in the courts in respect of enforcement due to frivolous objections possibly taken by us lawyers. So we might have to address this.
Yeah. One of the other things about Sri Lanka was ship arrest. Sri Lanka was very popular for this, dealing with ship arrests.
Yes.
There's a decline I see in the trend. Why is this?
Unfortunately, when you need to arrest the ship, you need to deposit security. So you need the services of several persons, the sea marshal, to arrest the ship. So sadly, there have been instances where the security deposited, due to the administrative delays, has taken a long time to take them out. So we have instances where it has gone for years. So it has to be attractive, because you need to arrest the ship, and then thereafter you should be able to immediately take your security out. So that process, unfortunately, due to the administrative delays, is taking a lot of time. And furthermore, there have been instances where certain ships have also fled. So those matters, I think, are concerns which we need to address.
Electronic technology, and lots of things are now done electronically all over the world. Can it address, you mentioned a whole heap of situations and circumstances and procedures which are causing delays, from arbitration to civil law to everything. But can the electronic technology, or technology per se, address this issue to some extent? Do you have any solutions?
If we introduce, there is an understanding, or there is a belief that if we introduce e-filing, that we should be able to solve this issue.
Were we thinking about it about 2 years ago?
Yes, we were thinking. I think we have tried it in the Mathura courts, we have tried it in the Supreme Courts. Yes. But merely e-filing, is that going to solve this issue? Yeah. Because we need administrative infrastructure to accommodate that. Is it doing, now you get the instructing attorneys in our profession, and you get the counsel. We are counsel, you get the instructing attorneys who would work on all the documentation. So now e-filing is where you would scan every document page by page, and then thereafter you would put it into a form of a soft copy and hand it over to the respective courthouse. Now that process of transferring information into a soft copy process is basically doubling the process, or doubling the work for the instructing attorney. Yeah. And that will all, because ultimately we counsel, we would want a settled brief. We will want that at our residence. We would want the instructing attorney to send the brief. So we, in addition to the paper, merely for the process of converting it, there would be an added cost. So merely introducing technology without addressing the roadblocks might lead into a bigger issue. And we would need competent persons in the respective administrative divisions with the respective intellectual IT background to be able to administer this. So all of this requires careful planning. It is not, you should not just think of, it's not a one-way thing, it's not one option, but it's a cohesive thing which we have to look at in order to address the issue of delays.
Nishan, Premathiratne, thank you very much for your kind thoughts and your very elucidate explanation on all matters. And thank you for taking your time off and joining Law and Order today. We wish you luck and success.
Thank you very much, Shanakya. Thank you very much for inviting me again.
And that's Law and Order for you today. We'll join you next week at the same time with another program on Law and Order. Enjoy the rest of the programming on Channel 9. Have a good night and a good weekend.